returning to the 1962 decision that initiated the official hostility toward public religious expressions, the entire controversy had begun over a 22-word voluntary prayer that the court struck down in the Engel Vital case. That little prayer, which led to the end of all school prayer and so many other public religious expressions, had simply stated, Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. That little voluntary prayer, which only acknowledged God and didn't even mention the word Jesus, was so bland that 8 years later it was ascribed by a court as a, quote, to whom it may concern prayer. Now that's bland. That prayer acknowledged God only once, the same number of times that God is acknowledged in the Pledge of Allegiance, and only 1/4 the number of times He is acknowledged in the Declaration of Independence. Yet somehow that single voluntary acknowledgement was unconstitutional. Since this prayer had merely acknowledged God, the court even went so far as to investigate what percentage of the nation at that time did believe in God. The court reported that only 3% professed no belief in religion, no belief in God. Significantly, 97% of the nation did believe. That 22-word prayer was consistent with the beliefs of nearly all the nation. Yet the court said that it was unconstitutional for students even voluntarily to say what almost the entire nation believed. This was another first by the court, in addition to 1, having ignored the actual wording of the Constitution, 2, having set aside precedent, and 3, then having elevated an 8-word phrase from a private letter above the Constitution itself. The court, having no constitutional basis and nothing more than its own preference, now, 4, sided with the 3% against the 97%. This was the first time in America's history that 3% had become the majority. This decision initiated the current policy whereby the philosophy of the small dissident group, that is the 3%, becomes the standard by which the rest of the nation, that is the 97%, must conduct its public affairs.
Religious individuals find themselves with less constitutional protection than secular individuals. Secular individuals have the right of free speech, and the court has now ruled that secular faith is a religious faith, guaranteed protection under the religion clauses. Now, if secularism, which is anti-religion, is a religion, then you've now said that anti-religion is a religion, and if you protect anti-religion under religion, you have just shot religion. There is no religious protection, and we have a number of rulings where the court has ruled that atheism is a religion. They've ruled that secular humanism, these are all religions without God, so how can you extend religious expressions, religious protections to people who don't have religious faith? That's where the court has taken us, and that's why now traditional religious people find themselves on the wrong end of nearly every issue. When it comes to where people are, it's real simple. You know, we've had for years a controversy over keeping under God in the pledge. 90% of the people want it in the pledge. For decades, the court has said you can't have prayer schools. For decades, the numbers have been rising. There's now over 80% of the nation that wants prayer in schools. And by the way, find me anything else that 80% of the nation agrees on.
Yeah.
You know, you can't. And so what happens is we hear from civil libertarians and critics that school prayer is divisive. No, the absence of school prayer is divisive. You got 80% of the nation that wants voluntary prayer to be available, that if you want to pray, you can pray. Well, it's the 20% that's running to 80%. It's the 10% that's running to 90%. Displays of the Ten Commandments that consistently runs between 70 and 80% of the nation wants public displays of the Ten Commandments. They don't win. It's the 20% that win because they say we feel like outsiders when we see things like don't steal and don't kill. You know, this is really nonsense. And original intent is so clear because now we can't have the Bible in schools, but Founding Fathers put the Bible in schools. This is the guy who did the First Amendment language. Now I would think the guy who wrote the First Amendment language knows its intent. And he in here says you can't let the Bible ever get pushed in the back of the classrooms in public schools. It's got to be our #1 textbook. This is the guy, Benjamin Rush, who's called the father of public schools under the Constitution. He has a lengthy piece in here giving a dozen reasons we'll never take the Bible out of public schools. Well, now we take it out because we say the Founding Fathers didn't want it. See, this is what happens when you don't know your history. It gets turned on its head, our policies get totally reversed, and that's been the case with separation of church and state.
For more information on the American Heritage Series, or to find books and other resources, visit wallbuilders.com. Through the American Heritage Series, renowned historian David Barton communicates our nation's forgotten, godly foundations and encourages us to once again view history through a truthful lens. For only when we recognize and embrace God's hand in our history can America become all that it was intended to be. Through Wall Builders, historian David Barton seeks to rebuild the walls of America's unique religious, moral, and constitutional heritage by educating the public and encouraging people of faith to become active in strengthening America's great foundations. For more information on how you can become involved, visit wallbuilders.com.